We're on the record.
All right, good morning, everyone. We're here for short calendar. Judge Kristen Connors for December 1st, 2025. We have two matters at 9:30 this morning, and then we have other matters later in the day. And both matters are involve claims of recklessness, whether it be one has just common law recklessness, one has statutory and common law. So we'll take them one at a time. I want everyone to know that I've read everything. I'm certainly going to keep an open mind. I've declared myself on these issues in the past. Again, we'll do the first one. It'll be Poland versus Alarcon. Hopefully I'm pronouncing that correctly. DBD CV 256054966. If those who are present for that matter could identify themselves for the record, and then for the other case, if you could please, and it looks like you probably already have, just mute your microphones. Thank you.
Good morning, Your Honor. I apologize for my voice. I have a cold.
I'm sorry to hear that.
Thank you, Your Honor. My name is Darren Altieri of the Flood Law Firm, and my office represents Mr. David Polland.
Good
morning, Your Honor. Emily Lanthier for the defendant on behalf of Attorney Dauscher, also from my office.
Okay, good morning.
Good morning.
All right, and so on this matter, it's a motion to strike at docket entry 106 and an objection thereto at 108. So I'll hear from the move-in.
Thank you, Your Honor, and I'll keep this relatively brief just because this was extensively papered by the parties here, but essentially, we are moving to strike counts 2 and 3 of the plaintiff's complaint, Your Honor. One of these counts alleges common law recklessness, and the other one alleges statutory recklessness. Essentially, in count 1, which sounds in negligence, there are certain allegations alleged. And then in counts 2 and 3, the allegations essentially incorporate the same ones from count 1, except under the guise that they are not reckless or not negligent now, rather, but reckless, either in the common law fashion or in the statutory fashion. With respect to the common law recklessness claims, Your Honor, we submit that the plaintiff has not alleged a sufficient factual basis to properly allege recklessness under the case law of our state, just because we do have case law that says that there's differences between negligent conduct and reckless conduct, and something more has to be alleged specifically with the state of mind. Essentially, what we're dealing with here is an allegation at the end of the day that the defendant was allegedly inattentive, which sounds in negligence as opposed to recklessness. It's pretty much the same argument for the statutory recklessness, Your Honor, except to say that merely incorporating some statutes that are contemplated by 14-295 does not meet the burden of pleading with specificity with regard to recklessness allegations and factual bases there too. So for those reasons, Your Honor, we would move to strike counts 2 and 3 of the complaint, as well as the associated prayer of relief.
All right. Thank you very much. And so I'll hear from plaintiff's counsel.
Good morning, Your Honor. Thank you. Essentially, this issue, I agree with defense counsel. This issue has been in front of this court on multiple occasions, as well as other courts throughout Connecticut. In my brief, Your Honor, I did cite to DiNapoli versus McDaniel, which is on all fours with our case. It is from 2018 in Stanford. Again, the court indicated that you don't have to water down a negligence count in order to trump up or thrust up your reckless count. In addition, Your Honor, the court in that case denied the motion to strike. And in addition, Your Honor, I cited 2 Supreme Court cases in my motion for common law recklessness. The first one being Craig versus Driscoll. And then the second case I cited as Supreme Court case was Williams versus House of Housing Authority of Bridgeport. both cases held there that the same conduct could be negligent and reckless. And then as for the recklessness counts, Your Honor, as you know, there is a majority view and minority view. And I did find a case that I did cite in my motion, which is Weiss versus Bauman, which is this court, Danbury Superior Court, by Judge DeAndrea. And the only decision I could find was Judge DeAndrea on September 22nd, 2021. The issue came before him about a motion to strike common law and statutory recklessness counts. He concluded that the plaintiff only need alleged statutory violation as set forth in 14.295 and need not plead additional facts, and that has to be properly pled and the defendant was properly on notice. Here, Your Honor, we did plead that the defendant made a conscious decision to drive while falling asleep and continued to drive, and therefore I would ask that Your Honor follow that case as well as the two Supreme Court cases and deny the defendant's motion to strike.
All right. As I indicated, I've sort of declared myself on the statutory recklessness in the past, but I will certainly look at this. I'm going to keep an open mind. There is a different analysis that happens with the common law, and I will also conduct that analysis. But what I'll do is I'll get a decision to you shortly so you can all move forward with your matter. So thank you very much. The oral argument is very helpful to the court.
Thank you, Your Honor.
Thank you, Your Honor.
Have a great day and feel better.
Thank you so much.
Okay. All right. Okay. So then the next matter is Kaufman versus Carolyn, DBD CV 256055220. This is a motion to strike at docket entry 103 and an objection at 107. If everyone who's present for that matter could please identify themselves for the record.
Yes, good morning, Your Honor. Attorney Rob Perugini from Trantolo for the plaintiff.
Right. Good morning.
Good morning, Your Honor. Claire McNamara from Milano and Wanted for the defendant, Carolyn Cohen.
All right. Thank you. Good morning. All right. So on this, I've read everything. I'm familiar with the issues, but I'll hear from the movement.
Sure. And again, Claire McNamara for the defense in this case. And I understand that the court has read everything, and specifically the defendant only moves to strike the common law recklessness claim. I do have a lot of familiarity with arguing on both, and I understand that the common law claim is held to a different, or in my opinion, a higher standard when pleading as opposed to the statutory claim. And I attached to the court, for the court's consideration, obviously not controlling, but for the court's consideration, a similar decision issued by Judge Stewart. It's Exhibit F to the motion, I think it's 104, the memorandum in support, in which Judge Stewart did a very nice analysis against me, by the way, but on the common law recklessness, in which she agreed that there were not facts enough alleged which would support a claim for common law negligence as required by the court. And I'm sure the court is very familiar with the standard for common law negligence, which means it's more than inexperience, excitement, or confusion, and more than mere thoughtlessness or inadvertence. In this case, what the plaintiff has pled essentially is equivalent to inattentiveness or distracted driving, as opposed to something that Judge Robinson said is egregious conduct in order to support recklessness. And the second, that goes into the requisite state of mind. And in this second count of common law recklessness, as complained in the plaintiff's complaint, the plaintiff pleads the defendant knew or should have known that her conduct in knowingly operating her vehicle while distracted, and then specifically talks about taking her eyes off the road or use of handheld mobile telephone, all of which are denied, resulted in this accident. That does not rise to the level of knowingly and reckless behavior, again, in the defense position. And the description or allegations of inattentive or distracted driving do not rise to the level of recklessness or reckless operation of a motor vehicle, and it can't be inferred that inattentiveness or distractiveness, which is the basis for a negligence claim, then you can't infer from those allegations that the plaintiff was actually reckless. And that's the basis for our argument as briefed in our motion and memorandum of law, and then similar opinions contained in cases cited not only in our brief, but also in that decision by Judge Stewart. And I'll entertain any questions if the court should have any. Thank you.
All right, I don't have any questions, but I'll certainly hear from plaintiff's counsel.
Thank you, Your Honor. I think what separates the common law count in this case before just mere inattentiveness is that we've alleged, excuse me, additional facts, which is that the defendant was leaving a driveway where there was foliage and blockage, and she couldn't see pulling out of the driveway. And if you look at our complaint just on the facts, obviously what is alleged is that she pulled out of this driveway not being able to see and made a left-hand turn and gunned it across the roadway into my client's vehicle. So it's more than just mere inattentiveness. It's now getting to the point where now it is reckless because you have knowledge that you can't see and that you're pulling out onto a roadway, which is conduct which would be greater than just not being inattentive. You're taking that extra step now you can't see, and now you're pulling into the roadway, which is more than just negligence. It's now reckless by pulling out into a roadway when you cannot see properly down the road. So I think that's what's distinguishing in my case, in our count of the common law. It's not just mere I wasn't paying attention. It was I wasn't paying attention, I can't see, and now I'm pulling out into the roadway into oncoming traffic. That's more than negligent. That's reckless conduct.
Okay. All right.
If I can just
Yes.
address that, Your Honor.
Yeah.
I have the second count and the first count in front of me, and the first count talks about the operation of travel in paragraphs 1 through 3, and then the collision, and the second count incorporates counts 1 through 3, or the paragraphs 1 through 3 of the first count. I'm reading it, and I don't, and this could be my reading, but I don't see anything which would support the plaintiff's claim that the allegations talk about foliage and the defendant's alleged inability to see because of the foliage. I don't see foliage mentioned anywhere in this count. I also don't see any indication that the defendant allegedly gunned it. The allegations are that the plaintiff exited her driveway and failed to grant the right of way, or failed to swerve, failed to have reasonable control, and or failed to make use of her senses and faculties. Those are all, again, supporting allegations of negligence. So I think that a fair reading of the actual complaint in the count 2, which is the common law recklessness, is not supported by the allegations contained in the complaint or referred to in the first 3 paragraphs of the first count.
And I'll concede I did add additional facts that's not in my complaint, so defense counsel is correct. But I will just go to my actual count of common law negligence, paragraph 4, in which I outline the conduct, and the conduct is that she knowingly operated her vehicle while distracted and or taking her eyes off the roadway, while using a handheld mobile device, and or exiting a driveway with knowledge that this is the big one here, knowledge that she could not see oncoming traffic, and that would result in a high degree risk of serious harm to others.
Yeah,
so I think
and I didn't mean to interrupt you, but one of the things that I remembered and was trying to find which one it was subparagraph O. And I think that has, you know, although not talking about the foliage specifically, does talking about taking a left-hand turn where could not see oncoming traffic. But I apologize, I interrupted you. I just wanted to make sure I could remember and find again the subparagraph.
Yeah, that's correct. And I like I said, I can see that I added some additional facts without my complaint, but I'll go to the actual language. And that's what I think separates my common law count than just mere negligence. I'm specifically alleging could not see oncoming traffic, but yet still proceeded and went anyway. And I think that's the crux of my common law recklessness count, is that additional facts right there.
Okay. All right. So I'm as I said, I've reviewed this. I'm pretty familiar, obviously, with the complaint. I was able to grab that paragraph pretty quickly. But what I am going to do is I'm going to take a look at this in light of the oral argument. I thank everyone. It's very helpful to the court, but I should be able to issue a decision on this shortly, and that way you can keep moving along with the discovery in the matter.
Thank you, Your Honor.
All right. So thank you both, and we are adjourned until noon for our next matter.
Thank you. Your Honor.
All right. Thank you, everyone.
Bye.
Give us 1 second, ma'am, okay? Mr. Clerk, you're on mute, I believe.
Apologies, Your Honor. I was having some technical difficulties.
No problem.
Would you like me to open court, Your Honor?
Yes, please.
Oyez, oyez, oyez. The Honorable Superior Court in and for the Judicial District of Danbury is now open and in session. All persons having causes or actions now pending before said session will give their attention according to the law. The Honorable Judge Fox presiding. Good morning, Your Honor.
Danbury Superior Court 12-125 foreclosure docket. I'm going to call the docket. If you hear your name or case, please let the court know that you're present. Wells Fargo Bank v. Minette Parr et al.
Good morning, Your Honor.
Good morning, counsel. Plaintiff's counsel present.
I'm not sure. I have Eric Kaneko as the attorney for the bank.
Yes, there is.
Or, okay. I'm not sure if there's another, one of these associate counsel is on there. If you want to take another, I can call.
Good morning, Your Honor. Attorney Thomas Kusa, McCalla Raymer, regarding Parr. Minette Parr, is that the matter?
That's good. Yes, counsel, yes. We are with you. Thank you.
We're here, Your Honor, yes.
TLOA Lending, LLC v. 289 Candlewood, LLC.
Good morning, Your Honor. That is ready. Attorney Uriel is having trouble logging in. He just called me and said that he'll be on. He's working with the clerk's office right now.
Okay, we'll be back to you momentarily.
Thank you.
Deutsche Bank v. Gant.
That's ready, Your Honor. Jessica Browse for the plaintiff, and I see Miss Gant also.
Yes, I'm here.
MCLPS, a company v. Beverly Rogers.
Beverly Rogers, present.
Thank
Ben
you.
Staskowitz present, Your Honor.
Thank you. Bank of New York trustee for the certificate holder of v. Daniel Appleby.
Good morning, Your Honor. Geraldine Shaburko for the plaintiff.
Good morning, Your Honor. Stephanie Nixie on behalf of the defendants.
Good morning. Thank you.
Applebee's.
Our first call matter, Wells Fargo Bank v. Minette Parr et al. DBD CV 236047581S.
Good morning, Your Honor. Attorney Thomas Kusa, McCalla Raymer, on behalf of the plaintiff.
Good morning, counsel.
And Attorney Kara Pavlik on behalf of the estate of Raymond Kovalek, Ms. Parr.
I believe there have been motion for open judgment filed by both sides of this matter, correct?
That's correct, Your
Yes, Your Honor.
Plaintiff proceeding March 14th.
Yes, our motion requested March 14th, Your Honor. My understanding is the estate is currently attempting to sell the property. So, as you say, since there are two motions, perhaps we should mark the defendant's motion off so they could reclaim at a later date if necessary, and possibly, as you say, just go forward with our motion since we're giving them until March. So,
Work for you, Attorney Pavlik.
And we would consent to that, Your Honor.
Okay, so ordered. Thank you both. Take care. Thank you.
Thank
all
you.
right, thank you very much, Your Honor.
Are both counsel present with TLOA Lending v. Candlewood now?
Yes, Your Honor. Thank you.
Okay, it's DBD CV 256053034S. Counsel, identify yourself for the record, counsel.
Good morning, Your Honor. Lawrence Garfinkel for the plaintiff.
Morning.
Good morning, Your Honor. Anthony Iorio on behalf of the defendant 289.
Good morning. The matter has been before the court a number of different times in the past as possible agreement or stipulation was going to be forthcoming. How is the matter going to proceed today?
Your Honor, last time I was here, I said that I wouldn't agree to any more extensions. It sounds like we are getting closer to a resolution, but we keep, as you pointed out, we keep marking this over, and at some point we need to move it forward or get it resolved.
Okay, so I know it looks like a payment was made recently towards the outstanding debt, I believe $50,000. So, counsel, do you want to tell me how you want to proceed? It's
Your Honor, I think the discrepancy really lies in the fact of in the affidavit of debt, there's a undelineated or undefined charges of 14,652. That's part of what I think has been the hangup to this point, is that there's a penalty or a charge, that is undescribed or at least disputed. And then additionally, I think there was an agreement to attorney's fees being capped at 7,500. And from what I understand from my colleague in the office here, those are the two outstanding issues.
Okay, so I guess how are we gonna move the matter forward today? You want
I
to hear
think
go forward on the motion to foreclose, or?
Well, Your Honor, if we could have further conversation about those two items, I think we would have a resolution.
How much more time do you need to have further conversations?
Your Honor, would you agree to 2 weeks?
Attorney Garfinkel?
To the extent that it matters, if we could make it final, I guess maybe I'd agree to that.
Okay.
That's I can't make that. I can't. That's not my. I'm not. That's not my purview. I think that's in Attorney Orio's purview and Attorney Garfinkel's purview. So both counsel are seeking a 2 week continuance. Is that what I'm hearing?
Yes.
Attorney Garfinkel.
Sure, Your Honor. Sure, Your Honor.
Okay, so 2 week final continuance. The underlying motion, which I believe is motion 109. See you in 2 weeks. Thank you both. Good luck.
Thank you. Thank you, Attorney Garfinkel.
Next person, Deutsche Bank National Trust Company, v. Robert Ronald Gant Jr. et al., DBD CB 256056147S.
That's ready, Your Honor. Jessica Browse for the plaintiff.
Morning.
Good morning.
Ms. Gant, are you present?
Yes.
What is your name, please?
Rebecca Gant,
Your address, ma'am?
9 Bayberry Lane, Danbury, Connecticut, 06811.
Thank you. Good morning.
Good morning.
Counsel, before we proceed on your motion to foreclose, there was a motion to participate in mediation, I believe entry 112. It's also on today's docket.
I didn't know if it was on the docket or not. I don't think that the defendants are eligible, but of course the court can use its equitable powers to do anything, pretty much. So,
yeah.
The problem we have, I think, is that I think correct me if I'm wrong, Mrs. Gant, but I think they have not been. I don't know where they are with probate, but I don't think there's been a certificate of devise.
We have a certificate of devise. I can't get the deed. I'm trying to get the deed because that's why I had the problems, because I couldn't get help because I couldn't get the deed for the house. They said the certificate of devise doesn't count as the deed. So I was trying to work on that so I can.
Okay. So counsel, in terms of that information, do you want to let you what do you want to give it more time for the motion to foreclose? You want to participate in mediation?
Well, let me ask you, Your Honor, is it possible to proceed with a judgment, give a very long sale date, and then maybe put the defendants in for one mediation?
I don't want to enter judgment before they go to mediation. I think that's somewhat counterintuitive.
Okay.
So if we're going to go to mediation, I'd like to go to mediation before we enter anything to judgment. So
Understood. So are you ordering it into mediation?
I believe so. Yes. Yeah. We'll give one mediation session.
Thank you.
Okay. And then Ms. Gant, if you're, if you don't have counsel, feel free to reach out so we can maybe get ready for mediation. It'll be productive. Okay.
Thank you so much. Thank you.
So the court just granted a motion 112 and we'll good luck mediation to all parties.
Just Your Honor, just for clarification, is that one mediation or the whole shebang here?
Why don't we start with one mediation and see where it can take us, okay?
Thank you.
Thank you.
Good luck to you all. Thank you.
Take care.
Next in the court's docket is MCLPS, Company v. Beverly Rogers, DBD CB 246050725S.
Morning, Your Honor. Beverly Rogers.
Good morning, Your Honor. Ben Staskowitz, McCalla for the plaintiff.
Your address, please, ma'am.
My address is 15. Well, all right. I don't know how to answer that question. I don't mean to be overly technical. I recently moved to 98 Old Town Farm Road in Woodbury in preparation for the sale of my house. So
that's the address you're receiving mail at?
The address I received mail at is 98 Old Town Farm Road, but my house has been on the market.
Thank you, getting a little ahead of ourselves. Thank you, ma'am. We're getting a little ahead of ourselves. We're here today at a motion for summary judgment 129. There was an objection filed, entry, I believe, summary judgment file entry 144. The continuance filed today's hearing. Counsel, did you see the continuance, counsel?
I have seen it, Your Honor. The one thing I'd like to add, Your Honor, is that all I did was get payment histories. The same payment history which would have been disclosed to Attorney Rogers in mediation. And I actually went back to verify it. Now granted, mediation happened many months ago, so this payment history just included whatever time in between, but it didn't change the due date of the loan. So saying that she needs 30 days to look at a document that has already been disclosed to her back in mediation just seems disingenuous, Your Honor.
I object to that.
Just give us 1 second, okay? Counsel, let's try to avoid the comments about the disingenuous thing, addressing motives to the other side. There's been a continuance request filed. I'm inclined to give it a brief continuance. I'm not going to give it a 30-day continuance. I mean, maybe one to 2 weeks, perhaps.
Yes, Your Honor. I'm starting a jury trial next week. So what day would you be looking to schedule this?
We typically do these on Mondays, so either Monday.
Oh,
the 8th.
I'd be able to do it Monday the 8th.
Okay. May I be heard, Your Honor?
Yes, please, Ms. Rogers.
Okay.
I think we're just, Mr. Rogers, we're just addressing the continuance request right now. That's all we're
I'm
addressing
sorry.
now.
I can't hear you, Judge.
We're just going to address the motion for continuance at the moment. We're not going to go into any details in my case. Okay.
Yes. Okay.
Okay.
With regard to the motion for continuance, there have been many errors in plaintiff's counsel's papers, notwithstanding his motion for summary judgment. I cannot be ready in 2 weeks. Christmas is coming up. I've got other cases. I have to look through every piece of paper that was just sent to me to make sure that what Attorney Staskowitz is saying, and I'm not accusing him of being disingenuous, but I need to check for myself that every piece of paper that was sent to me on Wednesday, the day before Thanksgiving, conforms to what I have with regard to my paperwork. And we still do not have discovery, which relates to a continuance. Attorney Staskowitz asked for December 19th to turn over discovery. So I don't have discovery yet. And Judge, I cannot be ready with the holidays coming up. I cannot be ready in less than 30 days. The plaintiff is not prejudiced. I am prejudiced, Your Honor, because if you read my disclosure of defense, and if you read my answer and counterclaim, it is clear that there are many, many issues in this case. So I believe that Your Honor would be compelled to deny plaintiff's motion for summary judgment. So I am
just without getting avoid getting the substance of the issue. We're just talking about the possible continuance request. The court's inclined to grant.
I'm sorry, Judge. I said I can't hear you, Judge. I'm sorry.
We're not going to get into substantive issues here. We're just going to speak about the issues.
Judge, I can't hear you.
Okay, well, we're here talking about this, the continuance request. You filed the request for additional time, correct?
Judge, I can't hear you. I'm very sorry.
You were able to hear me moments ago. Attorney Saskis, are you available 12:15?
Today?
No, December 15th.
Oh, yes, 12:15 I can do, Your Honor.
Yes, Roger, I'm going to grant the continuance request for 2 weeks. Okay, ma'am?
Judge, Christmas is coming on December 25th. I have a lot to do to get ready for Christmas. I cannot file a comprehensive answer for the motion for summary judgment in 15 days. Judge, I'm unable to do it, and the plaintiff is not prejudiced. I am prejudiced. My house is also on the market, so it may be, I've had 2 offers fall through because I need a new well drilled, and there was a crack in the septic pipe, so I fixed that. But a new well is going to cost about $25,000. And so I have to deal with that if I get another offer for the purchase of my house. I've judged most respectfully, I am asking you most respectfully to give me 30 days because the plaintiff, who's also the counterclaim defendant, is not prejudiced. The only party who is prejudiced here is me. And I don't want to come back on December 15th and say to you, I'm sorry, Judge, I'm sorry, Mr. Staskowitz, I tried my best, but I couldn't get it done. As Mr. Staskowitz stated in his second motion for an extension of time to produce discovery, he's had almost 4 months, Judge, to produce discovery, and he hasn't done that. He keeps asking for an extension of time. There's like 70 pages of documents he sent to me, and I'm telling you, Judge, that the plaintiff's work is sloppy, very sloppy. So I have to, Mr. Staskowitz, you should be embarrassed.
Ma'am, please, we're not going to get into that. Madam, the summary judgment was dated July 11, 2025. You filed the objection in October.
Judge, I can't hear you. You tend to speak a little fast for me. I'm sorry, Judge.
Ma'am. Okay, thank you, ma'am. The summary judgment motion was filed on July 11th. Your objection was filed October 24th. We're going to go forward with the hearing on December 15th, okay? December 15th, the matter is continued on 12:15 at 10:30 a.m., okay? This hearing is continued on December 15th at 10:30 a.m. Thank you all.
Thank you, Your Honor.
Next on the court's docket is Bank of New York as trustee v. Daniel Appleby, DVD CV 246-051-144S.
Good morning, Your Honor. Geraldine Shaverko of Eckerd Siemens for the plaintiff on the motion to strike the special defenses.
Good morning.
Good morning, Your Honor. Stephanie Nixie again for the Applebee's defendants.
Good morning. Thank you all. We're here for a entry 124 motion to strike by plaintiff's counsel. Your motion, counsel, please proceed.
Good morning, Your Honor. The defendant filed 5 special defenses, all of which I think should be stricken by this court. They include laches, equitable estoppel, unclean hands, failure to mitigate damages, and breach of covenant of good faith and fair dealing. As to the laches defense, Your Honor, The defendant states that he hasn't heard anything in 16 years, but he admits that he was in the military. He also hasn't lived in the property, upon information and belief, hasn't lived in the property, although he does consider it his primary residence. In this case, there hasn't been a loan payment since 2008. And the defendant also alleges that there were delays during the mediation process, which occurred in 2024. This would not support a laches defense, Your Honor, and I believe that that defense should be stricken. As to the second special defense, equitable estoppel, there are no allegations made by the defendant that the plaintiff engaged in any misleading conduct which induced the defendant to act to their own detriment. And the case law is included in my memo of law, Your Honor. Also, there is no allegation of false representation or concealment of a material fact besides those which relate to the 2024 mediation. As to the third special defense, Your Honor, which is unclean hands, there is no allegation made by the defendant of willful misconduct, and by his own admission, he has been in the service for in the military service, and therefore plaintiff was unable to proceed with a foreclosure action while he was still on active duty, and while the Department of Defense website showed that he was on active duty. There was also no allegation of willful or intentional misconduct or conduct designed to injure the defendants for which there is no just cause or excuse. As to the fourth special defense, failure to mitigate damages, any special defense or defense relating to the calculation of debt are premature at this time, Your Honor, as noted by in the M&T Bank versus 428 Hartford Turnpike Associates case, which was issued in 2025. Further, Your Honor, even if a failure to mitigate is proven, it does not defeat the plaintiff's cause of action in this matter. Lastly, the fifth special defense alleging breach of covenant of good faith and fair dealing is also subject to dismissal. Reliance, this is not an equitable defense to a foreclosure action, Your Honor, and defendant's reliance on Hudson United Bank in the opposition is misplaced, as that case did not involve a motion to strike. Your Honor, I rely on my moving papers as well as my reply, and I'm here can respond to any questions.
Thank you, counsel. Counsel Lieutenant?
Yes, Your Honor, thank you. The court must look at special defenses in a manner most favorable to sustaining the legal sufficiency of these. There is really no dispute between the parties that valid laches is a valid special defense, equitable estoppel is a valid special defense, and unclean hands are valid special defenses to the foreclosure. What counsel questions is whether failure to mitigate damages or breach of implied covenant of good faith and fair dealing are valid special defenses. And what we see from the history of foreclosures in the state of Connecticut is that there is no limit to the defenses placed on foreclosures by our appellate court or our Supreme Court, and that in fact over the years the court has expanded the scope of what these valid special defenses may look like. For example, M&T versus 428 Hartford Turnpike, a Superior Court case that counsel raises for failure to mitigate damages, is it's a Superior Court case, Your Honor, and it's never been cited since its decision. Whereas we know from our Supreme Court in 1980, Your Honor, Ham versus Taylor, 180 Con 491, 1980, a trial court in foreclosure proceedings has discretion on equitable considerations and principles to withhold foreclosure or to reduce the amount of the stated indebtedness. We also know that the breach of implied covenant, good faith and fair dealing, well, not a motion to strike in the Hudson United case, which is an appellate court case from 2004. It certainly undermines the 2002 case cited by opposing counsel. Let me bring you back, Your Honor, to the three claims that are not disputed now as defenses, special defenses to foreclosures: latches, equitable estoppel, and unclean hands. What I think counsel is really getting at is questions of fact that she would like to argue here on the motion to strike. I don't think that's the right place for that. You know, when my client was in the military, things of that nature. Rather, under the latches defense, we have the inexcusable prejudice, which is alleged, and that's due to plaintiff's delay, which satisfies the elements of latches. And in fact, you know, again, there are some points that are not disputed at all, Your Honor, which is the over 16-year delay here for bringing this action. We know from the pleadings in the complaint, my clients contest that there's any EMAP notice or notice of default. The question of whether the plaintiff has an excuse is, again, a question of fact for the court. Latches should be sustained here as a special defense. Equitable estoppel, Your Honor, allegations that SBS had no knowledge of any loan associated with Mr. Appleby's Social Security number or purported loan number, along with the 16-year gap between the default on the loan and the present action, is consistent with the elements for equitable estoppel. Yes, in fact, Mr. Appleby is now 100% permanently disabled while in active combat. And you know, all of that, you know, should be taken into consideration from an equitable court's perspective on that special defense. Similarly, unclean hands, Your Honor. You know, there's a case cited by opposing counsel which talks about, you know, the denial of an unclean hands special defense. But in that case, you know, what they're really talking about is a single failed mediation. And that was an appellate court case out of 2023, but it's so opposite of what we're dealing with here, Your Honor. Again, you know, the parties do agree about the 16-year delay. And, you know, my client goes on to say that how that improperly increased the defendant's overall indebtedness, which the court, you know, should very much, you know, have concern over. So for these reasons, you know, we believe that these special defenses should be sustained, and, well, the objection to the motion to strike should be sustained, and the special defenses should stand. Thank you, Your Honor.
Anything further, counsel?
Yes, Your Honor. First of all, there is a disagreement as to the three special defenses that counsel cites. We do believe that plaintiff does believe that they should all be stricken, not only the two that counsel references. This is not a question of fact, Your Honor. The special defense as drafted or as pled do not support any of the special defenses set forth by the defendant. Also, this calling it a 16-year delay ignores the fact that counsel or the defendant just admitted that he was in active duty for all those years, and plaintiff could not proceed with any foreclosure action. The fact that, or the allegation that the servicer had no knowledge of the loan, those are allegations relating that defendant alleges came out during the mediation. First of all, they're untrue, but that is not a basis for a special defense. Thank you, Your Honor.
Thank you. Attorney Nixie, anything further?
Your Honor, I think counsel is trying to argue facts, and so again, this is motion to strike. I think we're good.
Take it out of the papers, review the arguments as presented and issue a decision on the papers, okay?
Thank you, Your Honor.
Good luck. Thank you all.
Have a good day.
Thank you as well. Go off the record.
We're on the record. All right, good afternoon, everyone. We're here on Commercial Capital Bidco versus Young, DVD CV 246052498. If everyone who's present could please identify themselves for the record.
Good afternoon, Your Honor. This is Elizabeth Krasnow from Kelly, Dry, and Warren on behalf of the plaintiff, Commercial Capital Bidco, Inc.
Good afternoon.
Good afternoon, Your Honor. Jennifer Morgan from Harris Beach, North Carolina, for Joshua Young, Four Seasons Racket Club, and Spectre Investments.
Good afternoon.
Good afternoon, Your Honor. Sean Smith of McCarter and English for the defendant Standard Insurance Company.
Good afternoon. All right. So we're here on a number of matters. I want to make sure that we cover everything that we're supposed to. So if someone could follow along with me, and please absolutely correct me if I've missed something. So although already decided, what's relative or potentially relative to today is a prior decision on motion to strike, which is at 112.11. Then we have a third amended direct and derivative complaint at docket entry 161. The defendant's motion to strike at 211. An opposition at 295. And then a reply at 300. But then we also have the plaintiff attempting to cure what was acknowledged as not filing a motion to cite in Barrett, and also a request for leave to add Barrett counts. So we have a request for leave to file a fourth amended complaint at 290. The actual proposed fourth amended at 291. The red line at 293. An objection at 300. And then we have a motion to cite in George Barrett at 294. An objection at 302. Do I have everything that's pertinent to today's hearing?
Your Honor, I believe I'm sorry. Go ahead, Helen.
Oh, no, that's okay. I was just going to note that I think the opposition to the request to amend is actually docket 301 instead of docket 300.
Okay, sorry about that. Anything else?
No, Your Honor.
All right, so then I had a question for the group as we start. In light, and I have reviewed everything, in light of the posture on the third and fourth complaints, shouldn't we address the motion to cite in George Barrett first?
That's fine, Your Honor, if you'd like to.
Yeah. All right. Okay, so then I'll hear from the movement first on the motion to cite in, which is 294.
Absolutely, Your Honor. So we moved to cite in George Barrett as a defendant. Mr. Barrett is the manager of Spectre, and as we have uncovered in discovery, Mr. Barrett sat idly by and abdicated his managerial responsibilities to the defendant, Joshua Young, which is what enabled Mr. Young to commit the various forms of fraud that we allege in our complaint. As I understand it, the primary opposition to the motion to cite in Mr. Barrett really is procedural. So defendants are arguing that we should have filed the motion earlier when we filed the third amended complaint, and that when we filed the proposed fourth amended complaint that we should have included a memorandum of law. The court, and again, like I acknowledge, Your Honor, that we should have done those things. I'm not arguing otherwise. But what I am arguing is that the court has the discretion to nonetheless entertain the motion, and that any defects have been cured because we now have filed the motion and because we now have filed our reply memorandum of law. And I don't think that any efficiencies are served by denying the motion on those grounds now that we are where we are. Moving on to the actual.
So, and so before we do that, so I understood that one of the defendant's objections was that the practice book requires a memo of law. Is that correct, Attorney Morgan?
That's correct.
All right. Does the related statute require that? Or does the related statute just reference motion? The court would have preferred a memo of law, but it's a technical point that I think is important to me. So is it the case that the statute does not speak of the memo of law?
I believe that that's a practice book requirement only, and that it's not in the statute. And then we've cited some case law, trial court case law, but nevertheless, perhaps persuasive that that this was not a requirement that can be waived over the objection of the opposing party, because it's directed to the opposing party as well as the court. So just wanted to point that out to Your Honor as well.
Okay, so one of the things that we'll address perhaps for any of the attorneys.
Oh, Your Honor, we're having a hard time hearing you. I don't know if there's, sorry.
I get too close. So can you hear me now?
Yes.
All right, so one of the things that the court's going to be interested in, and obviously anyone, including Attorney Smith, if he wants, can address is, it's sort of, the rock, paper, scissors of practice book versus statute. I understand that the statute trumps, if you will. And so if the statute doesn't require a memorandum of law, just please let's consider that as we move forward, because that's one of the things that the court looked at. I do know I did look at and I see the references that you make to trial court decisions, but I'm also mindful of what we normally do when there is, as there can be from time to time, not a conflict, but maybe just different interpretations of a statute versus the practice book. All right. Okay, so if Attorney Krasnow, if you could continue, I'd appreciate it.
Absolutely. And I do, just because it is responsive to that last point, want to flag that we have filed a memorandum of law with our reply, and we have provided to the court a trial court case in which the court, comments on the fact that the court does have discretion to move past these types of procedural issues and in fact to consider the reply memorandum of law as satisfying the requirements of the practice book. But moving on, as Your Honor directed, to the actual merits of the motion to cite in Mr. Barrett. So I understand defendants to be making two arguments. The first argument is that we have not shown that Mr. Barrett is a necessary party. But we don't have to show that, Your Honor. So if Mr. Barrett is a necessary party, then it's mandatory that he be added. But if he's not a necessary party, meaning if the court can resolve our claims against Mr. Young without the presence of Mr. Barrett, this court nonetheless has the discretion to cite in Mr. Barrett based on a showing that he has an interest in the controversy between CCB and Mr. Young, and that Mr. Barrett's interest in that controversy is adverse to CCB. And I think it's clear that we've shown that standard based on an inspection of the allegations in our motion to cite in Mr. Barrett and the allegations in our proposed fourth amended complaint. The second argument that Mr. Young makes is that he will be prejudiced if Mr. Barrett is added as a defendant because Mr. Young may need to take additional discovery. He doesn't say that he will. He really tees it up as a hypothetical. He may need to take it. But importantly, Your Honor, he does not identify a single concrete item of additional discovery that he will require. Mr. Barrett's role in the events giving rise to our claims have been known to Mr. Young all along. We refer to Mr. Barrett in our original complaint. We have produced all documents that we have relating to the transactions underlying our claims, which includes any information we may have about Mr. Barrett. And Mr. Barrett also has been deposed already and questioned extensively about his role or really lack thereof in the management of Spectre. And so, absent any concrete showing of prejudice to Mr. Young, I would respectfully ask that the court grant our motion to cite in Mr. Barrett.
All right. Okay, Attorney Morgan.
Yes, Your Honor, thank you. So first of all, just to deal very quickly with the procedural issues, I think you're well aware of them, reading the brief, so I won't belabor them. But there were a number of failures to comply with the rules in the initial motion and in the initial just adding Mr. Barrett to the complaint without permission, and then even with the second kind of attempt to cure that. And these things we have rules for a reason. Adding a new party to the case involves issues of due process for that party and, changes the whole tenor of the litigation. And these rules are there for a reason. And so I don't think we should just dismiss them and say, oh, sorry, we've made up for it now. I think they are rules there for a reason that should be taken seriously and are independent bases to deny the motion to cite in if you so choose. I will note also, this is a matter for your discretion. We are not arguing otherwise that you are required to deny on that basis or, on any other basis.
I'm sorry, Attorney Morgan, you spoke just a little too quickly for me.
Oh, sure.
I'm sorry, were you agreeing that it's a matter of discretion for the court? I couldn't quite hear that.
Yes, overall, whether to grant a motion to cite in is a matter within the court's discretion. And there are factors for the court to consider. And our argument here is that those factors go in favor of denying the motion to cite in at this juncture. First are the procedural infirmities, which I guess are in a little bit of a different category. I mean, we would argue that those in and of themselves are grounds to dismiss. But looking at the merits I would kind of couple the two issues that Attorney Krasnow referenced, the fact that Mr. Barrett is not a necessary party, which I didn't hear the plaintiffs dispute that, but he is not a necessary party under the law because he is not required to be part of this case to assure a fair and equitable trial. The claims against the existing defendants, the 4 defendants, can be resolved without the addition of Mr. Barrett, so he is not a necessary party to the case. So when you take that, and also actually just to refer back to one other point that was made.
I think maybe I misheard again. The challenges of remote. I thought I was hearing the plaintiff's counsel, Attorney Krasnow, say that in acknowledgement that he was not necessary.
But maybe I misunderstood.
I still had
maybe I
my
misunderstood.
discretion. Is that correct, Attorney Krasnow?
That's absolutely right. So
Okay.
they're
Yep.
the mandatory addition of the party and then the discretionary addition of the
So-
party.
so
They're
that's-
not arguing that he's necessary.
So I think what the plaintiff was arguing that they have a sufficient showing that not necessary, but within my discretion to cite in and should cite in. Okay.
Yeah, yes. And again, I would agree with that on this point. It is within your discretion whether to do it, but nevertheless, the factors in our view, of course, favor denying the motion to cite in. And again, I think you have to kind of couple the issues. So we have the acknowledgement that he is not a necessary party to the litigation, which we all agree on. But then you have to couple that with the prejudice to the defendants of adding him at this juncture. And I just want to reference a point the plaintiff's counsel made in her argument, which is that, hey, Mr. Young has known all along about Mr. Barrett. He's in the original complaint. He's been a factor in discovery. And if that's true, why wasn't he added as a defendant from the beginning of the case? We are a year into this case. It has been extraordinarily active. As Your Honor knows, you spent a lot of time with us over the last several months in particular. We have had nonstop written discovery, depositions, etc., flying all over the country to do these things. There is no reason that Mr. Barrett was not added until the very end of fact discovery to this case. It's now December 1st. We are a month away from our motion for summary judgment deadline. We are 6 months away from trial. And, we're adding a brand new party to this case who is not a necessary party, is not required. Adding him will delay the trial. It will add new issues of discovery, whether it's to the defendants, and sure, Mr. Barrett will have some discovery he'd like to take if he's now added into the case, or, be filing motions, et cetera. It will complicate the case when we're kind of at the end of discovery and ready to prepare for trial. So it would prejudice defendants. It will delay the trial. He is not necessary to add as a party, and we'd ask that the court deny the motion to cite in and not allow Mr. Barrett to be added as a defendant at this juncture.
Okay. Which defendants are prejudiced? You said that,
I think all of them, because it's going to, it will extend discovery
well,
or
let's just hold on. So of the defendants that you represent, which this is an important point, so I'm going to spend a moment on it. So
Mr. Young, Four Seasons, and Spectre would all be prejudiced because this will presumably reopen discovery, elongate the course of the trial. It might change some of the issues in the case. We just don't know yet, but it will at a minimum extend the schedule, add to discovery, add to the burden and expense of this case, add issues to the case, and delay the trial, and all of those things are prejudicial to the defendants.
Okay, so I'll just ask Attorney Smith, is standard prejudice by the addition of Young? Excuse me, Barrett. Yes.
Standard is not taking a position on this motion,
Okay.
but otherwise, I fail to see how Standard would be prejudiced.
Okay, all right, thank you. All right, so now I'm going to ask Attorney Krasnow. I have a question. I'm hearing a lot about delay and additional discovery. Is there anything about the order for the defendants to comply in July of this year with the discovery that's been the subject of much motion practice? Is there anything about what has been produced more recently or produced late that goes to this issue of citing Barrett in?
That's exactly what I was going to say, Your Honor. You read my mind, because our claims against Mr. Barrett are based on the fact that while he was manager of Spectre, Mr. Young was diverting funds from Spectre to other entities in which Mr. Young has a financial interest. We didn't get the bank statements that showed those transfers until after we were forced to file a motion to compel, and this court entered an order of compliance. And then as soon as we got those records and we deposed Mr. Barrett, which we did in August of 2025, that's when we added him and added the claims against him. So we moved very quickly as soon as we received the information, but unfortunately we didn't have all of the information because it was withheld from us. And one more thing, Your Honor, just all this notion of like all this additional.
Okay, if you can hold that thought, just because I know it's hard. I don't want you to forget something, so jot it down. All right. So I see that the third amended complaint is dated September 3rd, right? 2025. What was the date of Barrett's deposition?
Oh my goodness.
It was in August. Okay. All right. All right. So the court doesn't think that there's a delay following his deposition. That I just want to make that clear. I think that we're having this hearing on September 1st regarding counts regarding Barrett that were filed back on September 3rd for a variety of reasons, right? There are objections, there's reply, then there's a fourth version. But in any event, it's significant to the court that his deposition was taken in August. It looked like Attorney Morgan was going to tell me the date.
August 28th, Your Honor.
August 28th. Look at that. And then there is an attempt to, albeit not procedurally correct, an attempt to add him or add information about that to the complaint. Okay. So Attorney Krasnow, I was interrupting you, so please go ahead.
No, I'm sorry. This is my fault. So I did just want to respond to this notion of like all this additional discovery. There has to be something more in terms of a concrete showing. Our claims against Mr. Barrett are incredibly straightforward. So all the discovery has been done and produced about these transfers. And the allegation against him is that he did nothing about them. There is no additional discovery that needs to be done. I haven't heard of a single document request or interrogatory or request to admit or anything that would need to be served. And as far as Mr. Barrett is concerned, I really think, once he is added and appears in the case, it's up to him to articulate what additional discovery he thinks he needs. But I haven't heard anything concrete about what the existing defendants in this case would actually need.
Okay. Nor have I. So, Attorney Morgan, do you have anything further on this point?
Yeah, just briefly, Your Honor, I don't know which is the case, but I've heard that the defendant should have known all along what the allegations are against George Barrett from the original complaint. And we've heard that this was just newly discovered in, at his deposition in August or afterwards. I don't know which is the case, but again, we're kind of conflating the two issues. If we've known all along, then they should have brought the claim against him earlier. And if we're just discovering it now, we're prejudiced by this new discovery that we now need to evaluate. I mean, hasn't even appeared in the case. We don't know what discovery he's going to be asking for. We don't know what this is going to do to, reopen discovery in many different ways. So it's hard to sit here and predict what will need to happen, but anything that is derailing this case, which is almost ready for trial, and that we're now moving to that phase with dispositive motions and trial preparation to now suddenly add new issues and new parties to the case, is prejudicial to the defendants.
All right. Well, okay, thank you. And so I know the parties have spent a great deal of time briefing the topic. It's something that I spent a lot of time looking at. I've also looked at the defendant's objection in light of what's happened with the compliance or lack thereof with the court's orders about giving complete discovery to the plaintiffs. And therefore, I do, and this is nothing as to the counsel, of course, but I do think the defendants who are claiming to be prejudiced come to the court with unclean hands. And so the court's assessment is in part based upon the fact that if the defendants had been fully compliant with court orders in July and October of 2025, which they were not, that perhaps the motion to cite in Barrett would have come sooner. That is discovery that was posed months and months beforehand. So for those reasons, the court is going to grant the motion to cite in George Barrett. So that now leads us to I guess, a collective conversation about tackling the status of the pleadings. So is it the party's belief that our energy should be focused on the fourth amended complaint and the motion, the motion regarding that? Or do you believe that the third amended complaint needs to be addressed?
Well, Your Honor, I guess we have two remaining things that were on the agenda for today: the motion to strike the third amended complaint, and then the request for leave for the fourth. So, if I'm understanding you correctly, are you suggesting that we should address the request for leave to amend first, as part of that, decide whether that fourth amended complaint will be allowed, and then figure out, okay, do we need to now rebrief the motion to strike to address the fourth amended complaint, or is that what you're asking?
Yes. So, for the I'm going to grant the request for leave to file it. Okay, that's in part why I wanted to decide the issue of the motion to cite in George Barrett. All right. And so I just want to make sure procedurally we're going about this, even though it seems it's backwards. George Barrett's going to be cited in. So that leaves a number of filings on the third amended complaint and the fourth.
Yeah, just briefly, I just want to make sure we're on the same page about this. The request for leave to amend, part of that was addressed to George Barrett, but yes, I'd say our primary argument there was about the total new theory of the case. And so I just want to make sure we're still going to address that, or have you already decided?
Yes, because as I understood it, I don't want to say half or a portion, but there are substantive arguments that the defendant is making that the repleading in response to the memorandum of decision on the CUPPA counts is something that the defendant still believes is insufficient. So I didn't mean to imply that that wouldn't be addressed. What we're going to have an argument. I'm thinking it should be the argument on the 4th, but if Attorney Morgan or anyone else wants to proceed with the 3rd amended, then now's the time to say so.
Well, I think the motion to strike the CUPPA claims in the 3rd amended complaint is equally applicable to the CUPPA claims that are replat in the 4th amended complaint. So, again, given all yeah, I'm happy to, so essentially apply the existing briefed motion to strike to the 4th amended complaint. Okay.
All right. So then what we're going to do is we're now going to proceed to hear the defendant's motion to strike the plaintiff's 3rd amended complaint, which is at 211. And we'll hear from the movement.
Okay. And I take it, Your Honor, you do not want me to address counts 13 and 14, which were addressed to George Barrett, and just focus on counts 4 and 5?
Unless there is an additional ground that you have about George Barrett that is just not based on the fact that he wasn't a party.
I think the only bases in the motion to strike were on the procedural issues, so I will treat those as moot for now and focus on counts 4 and 5 regarding CUPPA. So, so as the court knows, just to reset the stage, make sure we're all on the same page about the context here, the allegations in the, I guess now the 4th amended complaint arise out of a 6-month bridge loan from plaintiff to Spectre Investments, and CCB's claim that they were given a 35% equity interest in Spectre at the time the loan closed. Plaintiff brings claims related to the purported buyout of their equity interest in Spectre under the Spectre operating agreement, and claims relating to the management of Spectre. But plaintiff's claims and the factual allegations on which they are based relate solely to an intra-company dispute between the two partners of Spectre Investments, plaintiff and Mr. Young. As Your Honor knows, Connecticut courts, including the Connecticut Supreme Court and this court, in this case, have consistently held that intra-corporate disputes are not within the ambit of CUPPA. CUPPA is a statute to protect fair competition in the marketplace among businesses competing against each other for the ultimate protection of consumers. It does not apply to intra-corporate disputes. Those are disputes between private parties that do not affect the public at large, and the Connecticut Appellate Court has recognized that. They don't relate to competition among businesses in the marketplace. So the only time an intra-corporate dispute can form the basis of a CUPPA claim is where one partner usurps the business and clientele of one corporation in favor of another. And that's because if a partner is doing that, if they're usurping business and clients from one company to another, it's no longer an intra-corporate dispute. It's now a situation where one partner is in competition unfairly in the external marketplace with another. So the Supreme Court has said that to successfully plead, well, under the Supreme Court precedent at least, is to successfully plead a CUPPA claim and to get out of this intra-corporate dispute category, the plaintiff has to plead 2 elements. Number 1, that the conduct places the defendant in direct competition with the plaintiff, and also that the activity goes well beyond what the governance of the corporate entity permits. And that's because, again, this is a very narrow kind of lane, and the courts want to make sure that it's not abused and that we're not just like blowing CUPPA up to apply to every dispute. So here, there's no allegation, no factual allegation. There's a legal conclusion, but no factual or no facts to support the legal conclusion that Mr. Young was in direct competition with either the plaintiff or Spectre. The plaintiff alleges in their complaint that Mr. Young has diverted funds from Spectre to benefit himself and other businesses in which he has a financial interest. And of course, Your Honor, we dispute all this, but for purposes of motion to strike, we must accept it as true. But that's the allegation. He diverted funds to benefit himself and other businesses. But there is no allegation that Mr. Young is using funds or otherwise acting in any manner to now compete with the plaintiff or with Spectre. The plaintiff, according to its own allegations, is a commercial lender. Mr. Young is not. Plaintiff does not allege Mr. Young has ever engaged in commercial lending or that he took any action to usurp any business or clients from the plaintiff. And he couldn't. That's not his business at all. And there's no allegation to that effect. And the same with Spectre. Spectre is an LLC that holds real property. That's it. It doesn't have a business. There are no customers of Spectre. Plaintiff hasn't alleged that there's any ongoing business or any clients of Spectre, or that Mr. Young took any action to usurp Spectre's business or clients. Given the absence of these allegations, plaintiff's CUPPA claims must be stricken. In addition, the plaintiff has not alleged any conduct of Mr. Young that goes well beyond what the governance of Spectre permits. And I will not walk you through all this. It's in our brief and it's quite detailed. But the operating agreement gives, and by the way, the new operating agreement attached to the Fourth Amended complaint is the same as the Third Amended complaint. So if we are, I know we haven't quite addressed the request for leave, but if Your Honor permits it, it's the same in this regard. The operating agreement gives broad authority to Mr. Young as Spectre's manager. It gives full and complete authority to manage and conduct the business and affairs of Spectre. The operating agreement expressly allows Mr. Young as manager to make distributions to each member at such times and in such amounts as he shall determine in his sole discretion, in proportion to the members' respective positive capital accounts. Plaintiff never alleges that Mr. Young didn't have a positive capital account. They never allege that, you know, there wasn't a basis for Mr. Young to make distributions to himself. Plaintiff never alleges the plaintiff had a positive capital account or was otherwise entitled to any distribution at all. Plaintiff never says they were entitled to any funds. And in fact, the plaintiff alleges in the complaint, not that the plaintiff was entitled to funds that Mr. Young diverted, but that, oh, he should have just left it in the company. No basis for that he should have left it and repaired the roof or done something. There's no basis for that whatsoever. Nothing in the operating agreement that says he should have done that, or that he was not authorized to make distributions to himself as, you know, as a capital contributor to the company. So these provisions of the operating agreement are incorporated into the complaint because it was attached, and the plaintiff pleads no facts whatsoever that any distribution made to Mr. Young violated the operating agreement in any way. No allegation that the funds paid to Mr. Young exceeded his authority or that they were distributed contrary to any provision of the operating agreement. As this court has previously found, this dispute is a purely intra-corporate dispute. Plaintiff doesn't allege Mr. Young acted in any manner to usurp business or clientele of either the plaintiff or Spectre. Plaintiff has not alleged Mr. Young acted in any manner well beyond, even beyond, but certainly not well beyond what he was authorized to do under the plain language of the operating agreement, which is attached to and incorporated into the complaint. These CUPPA counts should, once again, be stricken on this basis. In addition, separate and independent basis for striking the CUPPA claims, there's no ascertainable loss. The plaintiff acknowledges that it was not entitled to any distributions. They never say in the complaint that Mr. Young should have made distributions to the plaintiff. They just say, should have kept it in the company. There's no loss to the plaintiff. And similarly, there's no loss to Spectre. Again, when you're bringing a derivative claim, you have to have a separate loss between the individual member and the corporate entity on whose behalf you're bringing the derivative suit. And there's no distinct injury here. So neither party has an ascertainable loss that would give it, that would allow the plaintiff to bring a CUPPA claim. In addition, the plaintiff, once again, fails to allege that Mr. Young was engaged in trade or commerce as defined in CUPPA at the time the acts alleged in support of plaintiff's CUPPA claim occurred. And Your Honor, this is a very important point. This is not a check the box or, just put in the allegation in the complaint. This is a fundamental necessary element required to state a claim under CUPPA. Again, CUPPA is a statutory remedy, and it is there for, ultimately the benefit of consumers. It is limited to defendants who are engaged in trade or commerce as defined in the statute, which includes, let's see, defendants who are advertising, selling, renting, leasing, or distributing services or property. There is no allegation Mr. Young was doing any of those things in being a member of an LLC that holds real estate. There is no way that his actions as manager could be construed as advertising, selling, renting, leasing, or distributing services or property in the state of Connecticut. And the plaintiff doesn't attempt to say otherwise, even though this is now our second motion to strike, raising this issue. It is their fifth complaint that they filed in this case. They are well aware that that is a requirement in our state to state a claim under CUPPA, and they don't even try to get around it. They cannot allege facts supporting that critical threshold element of a CUPPA claim. In addition to alleging that the defendant was engaged in trade or commerce, he has to be engaged in trade or commerce to the plaintiff. Again, this is for the benefit of consumers. There has to be a consumer relationship there, and there's certainly no allegation that there is any kind of consumer relationship between the plaintiff and defendant. So, plaintiff has not alleged that Mr. Young was engaged in trade or commerce, or that he was acting within his primary trade or commerce, which is another related concept to this element. So to sum it up, the plaintiff's CUPPA claims, counts 4 and 5, should again be stricken because for 4 independent bases. This is a purely intercorporate dispute. It is not within the ambit of CUPPA. Neither plaintiff has an ascertainable loss here. Mr. Young was not engaged in trade or commerce, so there's no allegation that he was. There's no allegation that Mr. Young was engaged in his primary business in doing the acts that form the basis of the plaintiff's CUPPA claims. So if the court agrees with any one of these bases, those CUPPA claims must be stricken again, and the defendants urge the court to do so.
All right. So I'm going to ask Attorney Krasno, I don't want to, I really would like for plaintiff to focus on how it is that they think the court spent a lot of time in this on the motion, the memorandum decision. That's why I referenced that at the beginning. And so the court is skeptical, quite honestly, that the newest version of the complaint overcomes the prior grounds to strike those counts.
Sure. So I'll start with the intercorporate doctrine, Your Honor, and the exception. So I think it's really important here to pay attention to the actual language that is used in the cases when the exception to the intercorporate bar is described. So appellate cases instruct that the exception applies where the defendant's actions place him in direct competition with the interests of the company, not the interests of the plaintiff, the interests of the company. Defendants acknowledge that the exception can be triggered where a defendant diverts funds from the party's shared business. But in an attempt to avoid application of the exception, they are trying to impose an additional requirement that just is not in the case law. So defendants are arguing that CCB also must show that the businesses that receive the diverted funds are in competition with Spectre or CCB. The Spectre decision that we cite in our papers, it's spelled differently, Your Honor. It's SPECTOR, resolves this issue against defendants. This case is dispositive. In Spectre, the defendants managed a company that held a shopping center. And the defendants diverted funds from that company to benefit other companies in which the defendants had a financial interest. And the court held that the exception to the intercorporate bar applied because the diversion of funds placed the interests of the defendant in competition with the interests of the party's shared company. The court did not discuss at all whether or to what extent the various businesses competed with one another. The only fact that supported the court's holding was the diversion of funds to other companies in which the defendants held a financial interest. Defendants have not and cannot distinguish Spectre. They point in their, I think it's in the reply brief, to the fact that the companies that received the diverted funds in Spectre also held shopping centers, but there is no indication in the court's decision that the shopping centers competed with one another. I think it is crucial to look at the court's holding, which is on page 133 to 134 of the reporter. There is no mention of the parties' properties competing with one another. The diversion of funds standing alone is what placed the interests of the defendant in competition with the interests of the parties' shared company. So not only is there no support in the Spectre case for the gloss that defendants are attempting to put on it, but the fact that two properties hold shopping centers does not mean that the properties compete with one another. The shopping centers could hold completely different businesses, in which case they wouldn't compete. One shopping center could be in Stamford and the other could be in Hartford, in which case they wouldn't compete. The only competition in Spectre, which is an appellate case, was the fact that the parties shared business and the defendants' other businesses were competing for the same funds. And those were the funds that were diverted from the parties' shared business. That is the same type of competition at issue in this case. Funds are coming into Spectre through its accounts receivable. Mr. Young is diverting those funds to benefit other companies in which he has a financial interest. And that conduct places Mr. Young's interests in direct competition with the interests of Spectre, which is the precise standard set out in the appellate cases. Defendants, again, have not offered any way around Spectre, and most of their cases do not involve the diversion of funds from the parties' shared company to other companies in which the defendant had a financial interest, and so those cases are irrelevant. That includes the two new cases that are cited in their reply brief, which I can discuss if Your Honor would like.
No, I read those, so
You read them? Okay.
Yep.
All right. So again, just to close up this aspect of it, because this was at the heart of Your Honor's decision, right? This is why the court granted the first motion to strike. And so in repleting this, we were very careful to be sure and confident that we had appellate authority that supported our new allegations, and we do. Spectre is dispositive, and the facts that were material to the outcome in Spectre are the same facts that we allege here. I guess I'll move on now to some of the other arguments that Attorney Morgan had raised. I'll start with trade or commerce. CCB also has adequately alleged that Mr. Young is engaged in a trade or commerce, and that the misconduct that we allege in our CUTPA claim is related to that trade or commerce. So we allege that Spectre was created for the purposes of holding the sports club, which is a commercial property. We allege that Mr. Young was the manager of Spectre or purporting to act as the manager of Spectre at all times relevant to our claims. We incorporate by reference the operating agreement, which says that the job of the manager of Spectre is to conduct the business of the commercial property and Spectre itself. And we also allege that Mr. Young diverted funds from Spectre in his capacity as manager or while otherwise purporting to control Spectre's affairs and funds. I have not heard any argument that management of a sports club is somehow not trade or commerce. And I also don't hear defendants to dispute that if there was a diversion of funds. I understand they dispute whether that's true or not, but taking the allegations as true, which the court must do on a motion to strike, I don't understand defendants to dispute that if there was a diversion of funds, that it would have occurred in the course of that trade or business, in the course of the management of the sports club. Instead, they're arguing that the allegations in our complaint are insufficient to support those facts, but that's inconsistent, I think, with the generous standard of review that applies on a motion to strike, which requires that our complaint be given every favorable inference. And when you give our complaint every favorable inference, we have alleged that Mr. Young manages the sports club and that the diversion of funds occurred in the course of his management of that business. I do want to address quickly, Your Honor, there is one new case in defendant's reply, the Ferentini case. If I don't address it now, I'm worried I won't have an opportunity to. It's on page 5 to 6 in their reply, and defendants cite Ferentini for the proposition that CCB can't state a CUPPA claim because its primary allegations are based on its loan, which is incidental to Mr. Young's trade or commerce. Your Honor, the facts and holding in Ferentini are distinguishable. In that case, the plaintiff made an oral loan to the defendant that the defendant used to form an LLC that operated an optometry practice, but the plaintiff was not a member of the LLC. The plaintiff was only a lender, and the plaintiff's CUPPA claim was based on the defendant's diversion of the proceeds of the loan to another optometry business, such that the plaintiff's loan was not paid back. And when the court dismissed the CUPPA claim, the court did so because the defendant was an optometrist and the business of optometrists is not obtaining or making loans. But here, CCB is a member of Spectre. We're not bringing our CUPPA claim in our capacity as lender. We're bringing our CUPPA claim in our capacity as equity owner of Spectre, and the diverted funds have nothing to do with our loan. And I'll also just flag for Your Honor that the plaintiff in Ferentini subsequently amended her complaint. And in her amended complaint, she did not base her CUPPA claim on her loan. She instead based her CUPPA claim on allegations that related to the business of the borrower, just as we've done here. And the defendant renewed its motion to strike and the court denied it. And the site for that is 2022 Westlaw 3279648.
I'm sorry, 9648, 9648.
I'm sorry, I said that so fast. 3279648. Okay. Next, unless there's something else the court wants me to turn to, I'll next turn to this concept that we haven't alleged that Mr. Young's conduct goes beyond ordinary corporate governance activities. Essentially, Your Honor, defendants are asked, oh, sorry.
All right, so it looks like you're starting that new section. So here's what I'm going to recommend, but I want to check in on everyone's schedules. Can we resume this at 3 o'clock? I already have a 2 o'clock.
That's fine with me, Your Honor.
I have something at 3, but I'll try to reschedule.
I did
It's not
this
a court
to-
appearance.
I did
It's a
this
client
to your
issue.
colleague last time and I felt terribly about it. So what does anything later than 3 work, or does your 3 o'clock going to take up the rest of your afternoon?
4 o'clock. I'm free at 4 o'clock.
Can we resume at 4 o'clock, everyone? Attorney Smith looks hesitant.
No, that's okay, Your Honor. I'm scheduled to teach a seminar at UConn Dental School, but if with the court's permission, I can have a colleague of mine attend and appear for the second part of the oral argument. And that would be I don't want to be the reason why we're holding this up.
Okay, well, the court appreciates that. So I'll work with the clerk. We'll get, I assume we can just use this same link again at 4. So we'll pause here. We'll resume at 4 with a colleague of Attorney Smith's, and we wish him well in his presentation. And I didn't want to cut you off, but I also wanted us to, start with a new topic, Attorney Krasnow. So, okay, well, thank you, everyone. So we'll see everyone at 4, and then we're adjourned until 2 for our other matters. All right, thank you, everyone.
Thank you, Your Honor.
Thank you, Your Honor.
We're on the record.
All right, good afternoon, everyone. We're here on the matter of Duran versus Ratner, DBDCV. I should be more specific. Ratner, Southbury Tree Service, Inc., and WRR, Inc. DBDCV 246050855. We're here for a hearing on a motion for summary judgment. If everyone could please identify themselves for the record.
Sabrina Kopp for the plaintiff, Ed Wald Duran. Your Honor, good afternoon.
Good afternoon.
Attorney Cynthia Garrity representing Neil and Doris Ratner.
All right, good afternoon.
Joshua Joy representing the third-party defendant, apportionment defendant, Southbury Tree Service, Inc.
All right, so again, the motion for summary judgment is at 142, correct?
I believe so, Your Honor.
All right. Yes, it is. So I'll hear from the movement.
Thank you, Your Honor. This is a claim for common law indemnity against my client. I'm sure Your Honor is aware of the elements that are required to prove a common law indemnity claim against a third-party defendant. Just to direct Your Honor, the focus here really is the third prong, which is whether my client was in control of the situation to the exclusion of the third-party plaintiffs, that would be the Ratners. There's no question that the court can rule on such an issue on summary judgment. There's plenty of trial court decisions that show that, and even the appellate court has agreed, obviously, if the facts warrant it, and that's the key issue. But, if the facts are appropriate, then summary judgment can be decided on common law indemnification issues. The fact that common law indemnification tends to be based on, a plaintiff's or a third-party plaintiff's negligence claim really isn't relevant to whether the court can rule on common law indemnification on summary judgment. Really, the focus of our argument here, Your Honor, is that the Supreme Court in that third element has defined exactly what exclusive control over the situation is, and they have defined it as exclusive control over the dangerous condition that gives rise to the accident. A reading of the complaint makes it clear that the dangerous condition that's being alleged here by the actual plaintiff is a tree, a branch that fell off and fell on the plaintiff. So, just like in a slip and fall and ice case where you often have common law indemnity claims, our trial courts have said, hey, obviously the dangerous condition is the ice. And the evidence here shows that the plaintiffs, the third-party plaintiffs, I should specify, the Ratners, were clearly in control of this tree to which the branch was attached. It's a branch that fell on the actual plaintiff, Mr. Duran. The third-party plaintiffs have admitted to possession and control of the premises at large where the tree was located, as well as the tree itself, in their answer to the plaintiff's complaint. And Mr. Ratner was deposed and said essentially the same thing. The Ratners have also admitted, responsibility for the maintenance and inspection, of the condition and the response to the standard interrogatories, as well as Mr. Ratner's deposition testimony. Mr. Ratner testified that he, primarily him, but I believe his wife as well, but they would decide what work got done on the property, particularly related to trees, and when that work got performed. Now, my client was at the property in December prior to the accident. So the actual accident occurred, I believe, in June of 2022. So my client was there end of 2021 in December. They show up to provide an estimate. As homeowners often do, they elicit estimates from different companies and they compare costs and see who they want to use. So my client showed up there, provided an estimate, agreed with the third-party plaintiffs what work was going to get done after they had walked the property together. There was no written contract, even in terms of agreeing to do the tree work, there was no verbal agreement to come back in 2 months or 3 months or 6 months or on some sort of regular basis. Basically, they're doing the work on the estimate and then that's it, unless they get called back to do more work. It's similar to the case I cited, the trial court case of Jackson versus Pasco, where in that instance, the third party defendants had not, been at the property in some time. Here, it was over 6 months since my client was last there when the accident happened. So they had no obligation or duty to return back to the property to do more work, similar to the trial court case of Palmieri and Metcalf Drugstore. The thing is, because it's been 7 months, the third-party plaintiffs had plenty of time to, walk around the premises, as Mr. Ratner often did. He testified that he had walked by this tree before the accident happened. And there's case law that says that when there's an opportunity to inspect, I believe it's an appellate case, McCann versus Real Equities. That's a demonstration of being in control over the dangerous condition that caused the accident. And that's what we have here, Your Honor. There's no dispute that the Ratners owned the premises or the tree itself. By way of background, because I don't think it's in any of the briefings or the complaint, this is a fairly large property. It's multiple acres. You've got hundreds of trees. And the Ratners certainly had control over the premises and the tree. And 7 months passed between my client was last there and when this accident happened.
All right, thank you.
Thank you, Your Honor.
Good afternoon, Your Honor. So it's our position that we're not talking about exclusive control over the entire premises, so the property. I mean, we obviously are not arguing that Southbury had exclusive control over the entire property, and we admit that we were in possession of the property. So that's not an issue. I think in this case, the issue is really what is the situation, right? This is not a slip and fall on snow and ice that's on the ground and you can see it, and a typical homeowner knows what ice is and can remedy and take care of it themselves. This is a situation where, your typical homeowner does not have the expertise or the knowledge to be able to look up 25, 30 feet into a tree and determine, is there an issue with a particular limb? Is there an issue with the tree that needs to be handled? They don't have the capability to do that type of inspection. And one of the allegations of the complaint is that the Ratners failed to properly inspect the tree. And the inspection is what we hired Southbury to do as the expert, to come in to inspect our trees and to advise the Ratners as to any defects, potential issues with the trees, or any work that needed to be done. And it's our argument that in this case, that's the situation, because the Ratners are not tree experts, nor I would guess is your typical homeowner like myself, and can't just figure out, if a tree, unless it's extremely obvious, right? You can't figure out what needs to be done. So that's our allegations, that Southbury was hired to come in and inspect this tree, and that they made no recommendations with respect to the limb or the leader, I guess is what it's actually called, that gave way in June. And Plaintiff's Counsel has just recently disclosed an expert. I think I included his disclosure, Mr. I don't know how to say his name, Uland or something like that, Uhland. And, he's going to opine that when Southbury was there in December, that they should have offered a level 1 inspection, which they did not do. Had they done a level 1 inspection of this property, that it would have led to this level 2 inspection, and it should have been offered to the Ratners, which did not occur. And he's going to say that should have been noticed, that there was an issue with this particular limb when they were there in December. So the fact that 6 months went by, I mean, they've submitted no evidence, nothing to suggest that there was any change to the tree in that 6 months, that there was something that occurred that changed it from when it was in December to June that maybe they should not have seen. I mean, it's their burden on the summary judgment, not mine. And so the fact that they weren't there in 6 months, I don't think is going to make a difference in this case based upon plaintiff's experts disclosure. He hasn't been deposed yet because he was just recently disclosed, but based upon the disclosure itself. So there was no reason for us to have them come back. There was no reason that's been submitted that we should have hired another arborist. Attorney Joy suggested that, there were multiple estimates given by multiple people, which is not actually the case. In December, the only estimate that came was from Southbury. We hired one arborist to come in and look at our property and tell us what needed to be fixed. There's no doubt that the Ratners, decided, what work was going to need to be done, but that I don't think that's the situation we're talking about. I think it goes back to the actual inspection and the recommendation of work to be done on the property. I think that, based upon Southbury's arguments, that would lead to a result where a landowner hires somebody with specialized knowledge to come in and do an inspection and do work, and that they'd never be able to, bring a common law indemnification claim against them because, the homeowner is in possession of the property. And I don't think that's what the case law stands for. I think the case law would permit common law indemnification in a situation such as this. And like I said, I think the burden is on Southbury as the movement to really establish that there is no material question of fact as to whether or not the Ratners may be entitled to indemnification.
I'm just taking a few notes. Anything else?
Yes, Your Honor, if I just may briefly respond to that.
Yes.
Just that the Supreme Court, again, they've defined what exclusive control is. And that has to do with the dangerous condition. So narrowing the scope to inspection or in maintenance of the tree because there's some sort of expertise required. That goes beyond what the Supreme Court has held. I'm not aware of any case law that's, found that you can narrow the scope further than what the Supreme Court has laid out. And again, I think it's a little bit different here because in the plaintiff's complaint, they've alleged that the Ratners possessed and controlled not just the premises, the tree itself, which again, the Ratners have admitted. And the tree is what caused the injuries, allegedly.
All right. Anyone else want to be heard on this?
No, Your Honor.
No, Your Honor.
Yeah, I kind of sort of meant Attorney Cobb. Okay. So, all right. I'm well aware of what your trial date is. I'm going to do my very best to move this to the front, if you will. So, thank you very much. The briefing is helpful. The oral argument is helpful, and I will do my very best to get this to you just as soon as I can.
Thank you, Your Honor.
Thank you,
Can I just
Your
put one
Honor.
thing on the record quickly, Your Honor?
Sure.
I don't think we covered it. WRR Inc., their counsel did reach out to the rest of counsel here and said that they took no position. So I just want to make sure that's on the record.
Okay, thank you. I couldn't recall if it was in this case or a different case where they had been asked to be excused. So I was just, thank you for that.
You're welcome, Your Honor.
Right. Okay, well, thank you, everyone. And have a great afternoon.
You too.
Thank you, Your Honor. Take care.
Yeah, bye-bye.
We're on the record. We can't hear you, Your Honor.
I'm gonna go. All right, can you hear me?
Yes.
Oh, and I can hear you. It's a great start. Okay. So we're back on the record in CCB versus Young et al. DBD 246-052-498. Thank you so much, counsel, for agreeing to continue the matter to later this afternoon. This is a hearing that began at noon today. Could all counsel please identify themselves for the record?
Good afternoon, Your Honor. This is Elizabeth Krasnow from Kelly Drine Warren on behalf of the plaintiff, Commercial Capital Bidco, Inc.
Good afternoon, Your Honor. Jennifer Morgan from Harris Beach, Martha Kalina for Joshua Young, Four Seasons Racket Club, and Spectre Investments.
Good afternoon, Your Honor. Banuka Mahabam Nagay of McCarter and English on behalf of the defendant Standard Insurance Company.
All right, thank you. And thank you again, everyone, for being flexible with your schedules. All right, so when we last left off, Attorney Krasnow was just about to address a sort of a new topic of ordinary corporate governance. So if you could pick up from there, that would be great.
Absolutely. Thank you, Judge. In their motion, defendants argue that Mr. Young essentially was authorized to use Spectre's bank account as his personal bank account, and thus it was within the bounds of ordinary corporate governance because Spectre's operating agreement authorizes the manager of the company to make distributions in accordance with each member's capital account balance. But the problem with that argument is that nothing in our complaint permits an inference that the diversion of funds to other companies in which Mr. Young has a financial interest was part of the permitted corporate governance of Spectre. Mr. Young is simply attempting to recast the payments to these other companies as dividends to Mr. Young in a way that really speaks past the allegations in the complaint. Whether and to what extent the payments to these other companies actually were dividends to Mr. Young is something that should be explored in discovery and litigated at summary judgment, not on a motion to strike. I'll also point out that we allege this same conduct, so the diversion of funds, in support of our breach of fiduciary duty claim against Mr. Young. And Mr. Young has not moved to strike those claims. So the same conduct cannot successfully state a claim for breach of fiduciary duty on the one hand and also be part of permitted corporate governance on the other. Looking at the allegations in the complaint in the light most favorable to CCB, which is the standard that we're dealing with at this time on a motion to strike, the only conclusion to be drawn is that the diversion of funds were not part of permitted corporate governance. On top of that, Your Honor, the authority that defendants invoke for Mr. Young to make these distributions is based on his status as manager of Spectre. But the complaint alleges that Mr. Young installed Mr. Barrett as manager of Spectre in August of 2024. And defendants do not argue that Mr. Young, as a member of Spectre, but not a manager of Spectre, had the authority to issue distributions. I did see that in their motion, the defendants point to the fact that the operating agreement also allows the manager to delegate his or her managerial responsibilities to others. And presumably defendants were attempting to make the point that Mr. Barrett could have delegated his authority to make these distributions to Mr. Young. But the section of the operating agreement that gives the manager broad authority to manage the company also states that no member other than the manager in his capacity as such shall take part in the management or conduct of the company's business. That's section 4.1, Your Honor. So while yes, Mr. Barrett could delegate his managerial responsibilities to other persons, he could not delegate them to Mr. Young, who at all times has been a manager of Spectre. I'll now move on, Your Honor, to what I understood to be the final point of opposing counsel's argument about the CUTPA claims, which is this issue about an ascertainable loss. So defendants are arguing that we haven't shown an ascertainable loss to CCB, and we haven't shown an ascertainable loss to Spectre. So they're attacking both our direct and derivative CUTPA claims on this issue. CCB did sustain an ascertainable loss because the diverted funds could have been used to improve the sports club, which would have improved the value of Spectre, of which CCB is an equity owner. And in this case, Your Honor, this injury is unique to CCB, and it does not also constitute an injury to Mr. Young, because Mr. Young used the funds to benefit other companies in which he, but not CCB, has a financial interest. Your Honor, we also allege that we exercised our right to withdraw from Spectre in March 2025, which triggered an obligation on the part of Spectre and Mr. Young to purchase CCB's equity interest in the company. And rather than make that payment, Mr. Young used Spectre's assets to fund other businesses in which he has a personal interest, which is another injury to CCB. We've also alleged an ascertainable loss to Spectre. Spectre sustained an ascertainable loss because the diverted funds, again, could have been used to make improvements to the sports club, which is the primary asset of Spectre. Making improvements to the sports club, of course, improves the value of Spectre. I don't hear defendants to be arguing that decreasing the value of Spectre somehow doesn't injure Spectre or doesn't injure CCB, which is a member of Spectre. What I instead hear them to be arguing is that we can't rely on the same injury. So CCB can't allege the same ascertainable loss as Spectre. We have alleged distinct injuries for the reasons that I just articulated, but to the extent the court finds otherwise, the solution is not to dismiss both CUTPA claims. The solution is to dismiss one. And if the court goes along with defendants' arguments, and if the court takes a look at the May versus Coffee case and defendants' papers, and again, I think that we have alleged distinct injuries, but this is just assuming that the court finds otherwise. The appropriate result is to allow the derivative claim to survive. And Your Honor, the full site of that case is 291 CONN 106. The year is 2009. And the pin site to the discussion that I think is instructive is page 118 of the reporter. So that's all I have on CUTPA, Your Honor, unless you have any questions for me. I think I did hit all the arguments that opposing counsel had raised.
Okay, so no, not on, CUTPA. Why don't we complete our discussion of CUTPA? So I'll give Attorney Morgan an opportunity to briefly reply.
You're on mute.
So this is incredible. It's not muted.
My apologies. No, we hear you. She didn't hear me. I was muted.
Okay. I was like, what
sorry.
happened now? No, that makes me feel better. I'm like, I don't know what's gonna.
No. Yeah, no, briefly just starting with ascertainable loss where we just left off, just to be clear, there are two arguments on ascertainable loss by the defendants. Number one, as counsel indicated, they cannot be the same injury. They must be distinct injuries. But number two, CCB in particular has not alleged any ascertainable loss because the loss that they allege arising from, again, this alleged diversion of funds, which we obviously disagree with, but for purposes of the motion to strike, the diversion of funds, they say in their complaint that they were not entitled to distribution of those funds, that, he should have kept it in the company, he should have left the value in the company. That is not an ascertainable loss for CUPPA purposes. It doesn't meet the standard. And again, that's briefed in our papers, so I won't elaborate unless you have specific questions on that. But going back to some other points raised by counsel, first of all, I just want to make sure it's clear on this intracorporate dispute issue. There are two components to it, and plaintiffs' counsel addressed them separately. But I want to make sure that they have to be addressed together to get over this intracorporate dispute hump, if you will. Both that the conduct places the defendant in direct competition with the plaintiff, and that the activity goes well beyond what the governance of the corporate entity permits. They must plead both to get over the kind of apparent intercorporate conflict that exists here. So the plaintiff claimed an argument that it doesn't need to plead that the defendant's actions place it in direct competition with the plaintiff in terms of usurping its business and its clients. It's enough to show that the defendant's actions place it in competition with the interests of the plaintiff. But Your Honor, this misstates Connecticut law. And again, I don't want to belabor this, it's in our papers, but I'll just quote from our Supreme Court in Ostrowski. Although purely intracorporate conflicts do not constitute CUPPA violations, actions outside the scope of the employment relationship designed to usurp the business and clientele of one corporation in favor of another fit squarely within the provenance of CUPPA. Our appellate court in Metcalf, a quote from that case, our Supreme Court has distinguished, however, internal corporate actions that also have the effect of usurping the customers, employees, or assets of one business in favor of the other business. There are many other cases cited in our brief that quote that standard. That is the standard under Connecticut law. And the case law is consistent in applying this standard. In the Larson case, which again is in our brief, I believe, the president of a realty company took a job with a competing firm, falsely told his clients in the business contacts, the old firm's going away, it's being taken over by the new firm, come over to the new firm. And he told the employees the same thing. That was usurping the business and clientele and employees of one corporation in favor of another. That was subject to CUPPA. Same thing in Fink about a medical practice. The owner of the medical practice formed a new practice, solicited the clientele of the first corporation, said, the other one's going away, come over to us. That is subject to CUPPA because that is usurping the clients and the business of one company. In contrast, the Russell case is an appellate court case from 2005, cited in our papers. The defendant, who is a majority shareholder, wrongfully detained the proceeds of a life insurance policy that should have gone to the company. But because he did not use the proceeds in a manner that placed him in direct competition with the company by usurping its customers, employees, or assets, no CUPPA claim was allowed. And the quote from that, the dispute here concerns only ownership interests and the proper distribution of the money. The dispute between the majority and the minority shareholders and the majority shareholders' failure to abide by their agreement doesn't affect outside interests. The courts have been very consistent in applying this standard, and plaintiff's argument that it should be a watered-down standard applied here simply is not the case. Now, the plaintiff's argument, I'm guessing, is based on, there is a quote from Fink, which is the medical practice case I just talked about. After quoting the standard about usurping business and clients of one company over another, it does say later in the case, in discussing the application, they kind of use a shorthand that, informing a new medical practice using the assets and soliciting the clientele of the first corporation placed them in direct competition with the interests of the corporation. So the case does use that language as kind of a shorthand, but they first state the standard that our Supreme Court has outlined in this area, and they stated very clearly that that is the standard that applies in this case. So you can't take a kind of summary version of that from later in the case, as for it's been well established that in that case, the defendant did usurp clients in business, and then say, oh, this is the new standard. That shouldn't happen. And we know that that's not the standard. If that was a standard that is just being, first of all, it's talking about, I think the way she referred to it is you're in competition with the interests, as if that means, first of all, I don't understand what that competition would be. I mean, it still invokes competition, which we don't have here. There is no competition between Mr. Young and either CCB or Standard under any scenario. So it seems that they want to go beyond the competition standard and just say, well, it's any injury, any harm. And of course, if that was the law, it would completely gut this entire line of cases we have on intercorporate disputes, because any intercorporate dispute where the corporation was allegedly injured would now be subject to this new watered down standard. It's just not the law in Connecticut. The plaintiff has talked and said that the defendants had not distinguished Spectre. We have, it was cited in both of our briefs on this motion to strike. But it doesn't change the well-established law of Connecticut at all. In that case, it was a totally different situation. There were 4 equal partners in a shopping center business. Each had contributed capital at the outset. There was no written agreement, but 30 years, of course, of dealing. They got profit distributions on a regular basis, the partners. And one partner was not entitled to a distribution that the others weren't. They were all entitled to equal distributions every time. The defendant Conover, that was the first shopping center, they went on to open 20 to 30 more that the plaintiff was not involved in. And the plaintiff claimed that Conover diverted distributions that the plaintiff was entitled to receive from the business for the benefit of the 20 to 30 other similar shopping center enterprises, rather than making the distributions to the partnership of the one enterprise. And there was one checking account for all 20 to 30 businesses. They were all treated as one entity from a financial perspective by Conover, the defendant. None of these circumstances are present in this case. We do not have equal partners. Mr. Young contributed 7 figures of capital, where plaintiff contributed 0. There was a written operating agreement incorporated into the complaint that provides for distributions based on the capital contributions. No requirement that the distributions be equal where the capital accounts are not. No allegation in this complaint that Mr. Young diverted distributions that the plaintiff was entitled to receive. The plaintiff doesn't claim they were entitled to receive any distributions. That's a very different scenario than.
And I believe we have covered that.
Okay.
I mean, I know we had the break, but I certainly don't have the command that you folks do, but I do have a command over what what the court believes to be the applicable law and how it applies to this matter.
Okay. So just my final point on this, Your Honor, is that most importantly in that Conover case, the defendant was using the funds to operate 20 to 30 other similar businesses. Very different than in our situation. So that was just one case among many, many in Connecticut discussing the intercorporate disputes in the context of CUPPA. The standard is clear. The application is clear. This court got it right when it struck the CUPPA claims before on this basis and should do so again. Very briefly on Trader Commerce, the plaintiff argued earlier today that Mr. Young was managing a sports club, and they've alleged he was managing a sports club and therefore was engaged in Trader Commerce under CUPPA. And I hate to sound like a broken record, Your Honor, I'll be very brief on it, but you could probably predict what I'm going to say. We have to go back to the statute. We have to go back to the statute and what it says Trader Commerce means. Advertising, sale, rent, or lease, or the distribution of any services or property. Managing a sports club does not fit within that definition. The plaintiff doesn't argue that it does. They're using kind of a colloquial, oh, it was business. He was engaged in business. That's not the standard. It's Trader Commerce under the statute. My final point is maybe I should just leave it here, but I just have to say, obviously, the defendant's decisions about what counts to move to strike and there should not be any inference from counts that we chose to move to strike and counts we didn't choose to move to strike about whether we are acceding to certain claims or think they have merit. We make strategic decisions. Thank you. Yeah. That's all I have, Your Honor. Thank you.
Okay, so I think we should move on to the other aspects of the filings regarding the 4th amended complaint.
So should I start, Your Honor?
So I'll hear from the movement.
Right. Okay. So that's me.
Yep.
So our motion to amend seeks leave to add allegations to our complaint that I think fall into two primary buckets. So the first bucket is allegations that Mr. Young altered the membership buyout term in section 0.9 of Spectre's operating agreement to include a buyout formula after CCB had approved and executed a version of the agreement with a flat buyout payment of $875,000. And the second bucket, Your Honor, is allegations that support our position that our loan is not fully paid off because CCB has not been paid anything for its membership interests. When I look at defendant's opposition, I understand it to focus only on the first bucket. So the only new allegations in our complaint that are cited or featured in defendant's opposition all relate to the allegation that Mr. Young altered section 7.9. So that's what I'm going to focus on. Your Honor, Connecticut case law is very liberal, as you know, in favor of allowing amendments to the pleadings. So unless our amendment would cause significant prejudice to Mr. Young or unduly delay trial, leave to amend should be granted. Here, in opposition to our motion, Mr. Young has not shown that he will be prejudiced at all. On this point, I think it is important to start by putting into context the limited nature of our amendment. So there are no differences between the operating agreement with the formula buyout and the operating agreement with the flat payment buyout, other than that term itself. So because of that, permitting CCB to amend will not impact any of CCB's claims that Mr. Young breached other sections of the operating agreement, and it also will not impact any arguments the parties may make regarding the interpretation of any term in the agreement except for 7.9. So for example, you heard arguments today that relate to the sections about distributions. None of that is impacted by our amendment. The amendment, Your Honor, also doesn't change our theory of the case, because we have been alleging all along that the parties agreed that CCB would receive a payment of $875,000 upon a refinancing of our loan. That allegation was in our original complaint. We allege that the parties intended for CCB to receive $875,000, but even if the formula governed, Mr. Young still breached the parties' agreement because he paid CCB nothing. And the allegations in our proposed amended complaint take the same approach. The only difference is that we now can have added the additional allegation that Mr. Young altered section 7.9 after CCB executed the agreement. Mr. Young also has taken extensive discovery about our allegation that he altered the operating agreement. We served amended discovery responses that contain that allegation. We produced all documents that we have relating to that allegation before Mr. Young deposed a single CCB witness. And his attorney extensively questioned 5 CCB witnesses regarding that allegation, including our CEO, our COO, and Carlton Drumright, who was CCB's deal counsel in connection with the loan. And I think it's important here, Your Honor, that in his opposition, Mr. Young does not identify, again, here, similar to the issue with Mr. Barrett, He doesn't identify a single document request, a single interrogatory, a single request to admit, or a single deposition question that he would have served or he would have asked had we sought to amend our complaint earlier. And because of that, Your Honor, his claim that he now is somehow prejudiced and his additional claim that the trial in this case will be delayed because of our proposed amendment are unfounded. I'm going to switch gears for a little bit from the issue of prejudice because Mr. Young also.
Can I just ask one question before you shift gears? When did plaintiff learn about the alleged alteration of section 7.9?
We didn't discover it until we were in the course of preparing for depositions in this case. That's actually the part that I'm turning to next, Your Honor.
All right.
Yeah, because I think that's relevant to the whole negligence argument that defendants are raising. So defendants are arguing that our motion for leave should be denied because CCB was negligent in amending its complaint to add this allegation about section 7.9. Before I get into why that's not true, I do want to point out, Your Honor, if CCB's allegation that Mr. Young altered the operating agreement is true, denying CCB leave to amend its complaint would allow Mr. Young to benefit from his fraud. I think that is an offensive result, and I think it also is contrary to the liberal standard that allows amendment to the pleadings. And I do want to point out, Your Honor, that courts have allowed amendments even where they found that the plaintiff was negligent, so that the case could be resolved on the merits and on an accurate record. But in any event, Judge, CCB was not negligent. As our witnesses explained at their depositions, CCB had no reason to suspect at the time of the underlying transaction that Mr. Young had altered section 7.9 without comment after CCB executed the agreement. So when CCB received back the agreement from Mr. Young's counsel, CCB did not check the agreement and unwittingly made the altered operating agreement part of its files. By the time that CCB did have reason to check the agreement, CCB assumed, rationally so, that what was written was accurate and that perhaps CCB had agreed to the change in section 7.9, but had no recollection of doing so. CCB simply did not suspect that Mr. Young's fraud would go so deep as to alter the operating agreement. And the fact that the agreement came to CCB from Mr. Young's counsel also lent it a sense of legitimacy. We lay this out in our reply brief, Your Honor, but in discovery in this case, we have uncovered what I think is a shocking number of additional lies and fraud that was perpetrated by Mr. Young, including lies about his education, his finances, the existence and terms of other agreements. We've deposed several witnesses who have accused Mr. Young of fraud and whose testimony has revealed additional lies that Mr. Young told in an attempt to get a deal that he did not bargain for. And it was not until CCB was in the course of preparing for depositions in this case and looking back through the versions of the operating agreement and looking back through the communications relating to the operating agreement and knowing what it now knows about the depths of Mr. Young's fraud, that CCB pieced together Mr. Young's alteration of the operating agreement. I think it's important to remember, Your Honor, that the only person telling CCB that CCB had agreed to the formula buyout is Mr. Young. CCB, there's no written record of CCB agreeing to the change. No one at CCB recalls orally agreeing to the change, and CCB's deal counsel, Mr. Drumright, is adamant that he did not approve the change. So again, it was when CCB reviewed the agreement, reviewed the communications in the course of preparing for depositions, that CCB realized what had happened and that the agreement had been altered. And the court can see that if you take a look at the agreement, because you can see that there's discrepancies between the second to last page and the signature page. So what the documents show is that CCB signed and executed a version of the agreement where section 7.9 called for a flat buyout of $875, and CCB's signature page was then put into an agreement that had been altered and instead called for a formula buyout. It was not negligent of CCB to rely on the good faith of Mr. Young and his counsel in assuming that what Mr. Young's counsel sent back was an agreement without alterations. That Mr. Young was able to deceive CCB for as long as he did is not grounds to now deny CCB leave to amend. Essentially, what Mr. Young is arguing is that the consequences for what he claims is CCB's negligence, which again, we dispute is negligence, should be to preclude CCB from offering what it believes to be an accurate version of events. That is an unsupportable position, in my view. It's especially unsupportable given that when CCB sought leave to amend its complaint, trial was 8 months away in this case. And even as we sit here today for this argument, the pleadings still are not closed. Mr. Young has not offered a single case where a court denied a motion to for leave to amend a complaint in a case that was in a similar posture. Mr. Young is free to attempt to impeach CCB's witnesses at trial by pointing to prior versions of CCB's complaint or using the deposition testimony that Mr. Young elicited. But the solution is not to preclude CCB from amending its complaint. I don't think that Mr. Young has offered a basis in fact or law for denying our motion, and I ask that the court grant it.
Thank you. All right, Morgan.
Thank you, Your Honor. I need to make one thing abundantly clear, and that is that there is nothing that the plaintiff learned in discovery that caused this about face a year after they filed suit. In other words, when they're saying, oh, we discovered it was the wrong operating agreement attached to the complaint, there's nothing that they learned in an interrogatory response or in a document produced by the defendants or in deposition testimony. Apparently, their client read the complaint or read the agreement in preparation for deposition and said, oh, this isn't the agreement. That's their story. I don't know whether it's true or not, but that's what we're being told. But I just have to make it clear. This is not due to anything learned in discovery. So when we talk about negligence, when we talk about why didn't this happen sooner, it's because what we're being told is that the client never read the agreement. I mean, this contract, this operating agreement, has been attached to every version of the complaint. We've now had, well, there were 4, and then now we get a different one for version 5 of the complaint. It has been attached. It has been quoted from. It's been the subject of motions and discovery and depositions, and specifically the buyout formula. The buyout formula itself has been discussed over and over and over. For them to say now, a year into this case, oh, there's no buyout formula. It was a different version of the contract. That, again, not due to anything learned in discovery. That is just because they didn't read the contract until they were preparing for deposition. That is the definition of negligence. Mr. Young and the other defendants I represent should not be prejudiced by having to restart this case now, 10 months into it. We are now 30 days from when our motion for summary judgment is due, and we don't know what contract we're going on. It's a very different motion for summary judgment if it's contract 1 or contract 2, completely different. We're starting trial in 6 months. We're disclosing experts next month. We don't even know if this is based on how we're interpreting the buyout agreement of the operating agreement, which is what we thought this case was about up until now, or is it about a meeting of the minds? And what contract, is there even a contract? Maybe there was never a contract between the parties. That wasn't an issue before, but now it is. That's really the central issue in the case. So when, counsel says, oh, this is just a small change, it's just about the buyout agreement, that's the only provision that's different between the two. That may be so, that's the key. I can't say every other provision is identical or not, but that is the key provision that is different. But that's the whole case. That was the whole case before, was a breach of that agreement. And then everything else kind of flowed from that. But that was the threshold issue in the case that if the defendants prevailed on, the case is over. And now we're being told that that is not the contract in this case. And again, it's injecting all sorts of new issues in this case. Primarily, was there a meeting of the minds? Everything relating to the discussion, the negotiation, and the DocuSigns back and forth, and the email metadata, and everything else. All of that's now the central issue in the case. So this is a complete about face, a completely different theory of the case than what we've been dealing with this whole time. One of the factors to consider, the factors to consider, this is within your discretion, of course, length of the delay, negligence of the party offering the amendment, and the fairness to the opposing party. Starting with the fairness, again, this case has been going on for a year. Fact discovery is over. Motion for summary judgment deadlines in a month and trials in 6 months. Plaintiff is seeking to change the theory of the case. Allowing the plaintiffs to do this now, after discovery is closed, et cetera, is completely prejudicial to the defendants and should not be permitted. We have served written discovery. Everything was based on the original theory of the case. We did not learn. We learned informally in a meeting on October 15th that just out of the blue, by the way, the operating agreement we've all been dealing with is not that, we never agreed to that, and this other operating agreement applies. Had never even heard that until October 15th. The only depositions we took in this case, we've spent a week in Nashville deposing all of the CCB witnesses. That took place the week of October 21st. So less than a week after hearing informally that they were changing the entire theory of the case, we took all of the fact depositions in the case, and fact discovery closed on October 31st. We had to get those done. So yeah, did we ask questions? Sure. Did we do the best we could in these, really incredible circumstances? Yes. We weren't going to we asked questions about both contracts because we didn't know which one we were going to be operating under. But to say that no prejudice, I got to ask questions at deposition. It was less than a week after we found out about it. We'd done no written discovery. We hadn't had a chance to do the legal research, figure out, what the admissions we need under this new theory or anything. We were just flying by the seat of our pants trying to get it done. And by the way, I was on trial in another case, so my colleague came in to take those depositions. I wasn't even there, their lead counsel. So the defendants absolutely are prejudiced by this change. And, to say it's not credible to say otherwise, frankly. In terms of the length of the delay and the negligence of the plaintiff, they are absolutely intertwined. Again, this case was filed a year ago, and they waited a year after bringing this claim to out of the blue say that the operating agreement at the center of this litigation is not actually the party's operating agreement. I heard that, the only one saying it's the operating agreement is Josh Young. No, he's not. The plaintiff filed the suit. The plaintiff attached the operating agreement. The plaintiff cited over and over and over in every filing and every writing that this buyout provision, the formula, you can't confuse them, the formula-based buyout provision was breached. Josh Young didn't say that. The plaintiff brought these claims. Saying that they just realized this defies credulity, given the number of times they have obviously read it, analyzed it, quoted it, developed theories of liability arising from it, propounding written discovery based on it, and taking depositions about it. It is astounding for them to claim now, a year later, after a very active year, chock full of motions and discovery and activity, that this is not the operating agreement they agreed to. The key provision at the centerpiece of this case is not a provision they ever agreed to. But even if that's true, that is entirely due to the plaintiff's negligence. They brought the case, they had a duty to investigate it and bring claims in good faith. They had a duty to read the operating agreement that they alleged formed the basis of their claims. There is no legitimate basis for plaintiff's failure to attach the correct operating agreement to their complaint, to use the correct operating agreement, the one that they say is correct, as the basis for their claims, and no basis for it taking a year to discover this mistake, to the extent it was one. The failure to do so rests squarely on their shoulders, and allowing them to make this change now is not fair to the defendants and will severely prejudice the defendants. The court should not allow it. It should deny the request for leave to amend.
Okay. All right, I'll allow a plaintiff a brief reply.
Thank you, Your Honor. I want to be clear. I did not argue, and I've never argued that I didn't read the contract. Obviously I did, and obviously my client did. But what I am saying is that neither Kelly Dry nor CCB noticed that the agreement had been altered. And that's only clear if you inspect the penultimate and ultimate page of the agreement, which we would have had no reason to look at, because there's no term on the penultimate page that is material at all to any of the claims that are in this case. And so, again, what I keep hearing is this theme of negligence. So because CCB and because Kelly Dry didn't notice this issue sooner, that we should somehow be precluded as the case moves forward from presenting testimony and evidence that we believe to be accurate. And again, Your Honor, I don't think that this was negligence, because I think that it is understandable that a party repeatedly presented with versions of an agreement by the attorney of their opposing counsel and told, this is what you agree to, could accept that proposition. But in any event, it is contrary to the truth-seeking function of the court to say, well, now going forward, CCB should have to accept this operating agreement, regardless of whether it was altered, because we're just too late in the case. And by the way, Your Honor, again, none of the cases that defendants have cited suggest that we are too late in the case to make an amendment to our complaint. They have cited no case where leave was denied when the case was less than a year old, trial was 8 months away, and the pleadings were not even closed. So what their argument really comes down to is that they don't believe me and they don't believe my client. But that's an issue and an argument that they can raise with the jury. It's not a basis to preclude my client from amending their complaint.
All right. Okay, so, all right, so the court, thank you. Argument's very helpful. The court has ruled on the motion aside in. The court's going to need to look further at the CUPPA claims in the, as briefed as to the third complaint, but applicable also to the fourth, should that be allowed, and also these additional issues. So thank you. I'm very much aware of the time frame that's approaching us. I'll work just as quickly as I can on this. Like you, there are other matters that the court has. I'll probably see Attorney Morgan tomorrow on a different matter. So, please understand the court is always mindful of when parties are waiting to hear. And we're just doing our very best to address it in a thorough and complete way.
And Your Honor, along those lines, if I may just ask, you can think about it if you'd like, but if we could have an extension of the MSJ deadline until 30 days after a ruling on the request for leave to amend, because truly we can't even begin to prepare it when we don't know which contract we're going on. So I can make a written request if you'd like, but again, I don't want to inappropriately rush you on that decision, but we will need a little time.
So where are the parties on that request? Or do you need time to consider? I don't know if that's something that you've all discussed before.
I just thought of it, so I did not run it by them in advance. My apologies.
Actually, Your Honor, so you had ordered us to submit a new scheduling order in any event because we had the issue with our expert deadline. So maybe what makes sense is for me to put that together and send it to the parties to take a look at and approve, and then we can file it. And as it's part of that negotiations, we'll discuss this request.
All right, and so that reminds me that there are a couple of verbal orders at our prior hearings that when I was preparing for this argument today, I don't know if those made that into a written order. And I will always want counsel to feel comfortable prompting the court with a case flow request. If you see that there's an order that hasn't, gotten into the docket. And so for the new scheduling order, I'll enter an order on that right now. When do you believe that'll be submitted?
I think we could do that. Is Friday okay, Your Honor? Just to give us a couple days to
That's
confirm.
fine. That's also the date, again, another order that was verbal but didn't make it into the docket. I want to make sure it does. Isn't that also the date for the new protective order?
I believe so, Your Honor.
Yeah, okay. All right. Okay, so I'll enter those now. Okay. All right. Well, thank you everyone for this. This was very helpful. And thank you for juggling your schedules to attend. So not having heard that there's anything else we need to address that, associated with today's hearing, I think I'll have everyone wish you a good evening.
Thank you, you too. Thanks for accommodating us today. Appreciate it.
Okay. Thank you.
Bye-bye.
Thank you to the court staff for assisting.